कम 10 मिनट पढ़ सकता ये Then he mentioned in the item of my loss, item number, number. This has some urgency lot. This needs to be taken up during the circuit lot. The item is its last in the motion. This has not. I prayed for certain interim protection because we have just 3 days left, literally 2 days left. Last day, no work could be done judicially, not most. But this has to be because the matter is listed in such a place. Well, it may happen so that I am in the court number 1 on the other side may take time. But this some interim protection has been claimed for lordship. Main matter cannot be decided now, but I do praying lordship. This has to be taken up today. I think service has been effected. I filed a service. Advance copy is given to the council court authorities as an abundant precaution. You some interim protection I paid.
Okay, let me call out the matters.
Fine,
I'll take on.
Item number on CRM 19 of 2023.
My lord, I am appearing for the petitioner, my lord. My lord, the issue, last occasion, the matter appeared and my lord has directed them to produce case diary. My lord, the matter is, my lord, before my lord looks any paper, my lord, the matter is that I am a medical officer, homeo. I appointed way back in the year 1994 on contract basis. And yearly such contract was extended by the medical department on the basis of my performance. Now, my lord, in the year 2002, a purchase committee was constituted for the purpose of purchase of homeo medicine and Ayurvedic medicine. At that junction, there were only 3 to 4 homeo clinic and 3 to 4 Ayurvedic clinic. Therefore, one committee was constituted under the chairmanship of Directorate of Health Service. Now, my lord, whenever the medicine pertaining to homeo is to be purchased, I would be the technical person for the procurement of said medicine. Likewise, when there would be any procurement with regard to Ayurvedic medicine, the Ayurvedic doctor, there was one Dr. Rajesh, he was the technical head to purchase the said medicine. He will give the intent and on the basis of that procurement will be done. My lord, in the year 2005-2006, certain procurement of Ayurvedic medicine was done. Subsequently, it was found in the year 2012 that the said procurement was made at an exorbitant rate and the firm which supplied and which participated are the one firm belonged to his wife, one to his father-in-law, one to his brother-in-law. And he procured it at a higher rate. The moment it came to the knowledge of the authorities, he was also a contract doctor. The authorities issued a so-cause notice to him, and at the same time, an FIR was initiated against him under the Prevention of Corruption Act. Now, after giving the so-cause notice, immediately on 22nd of January 2013, he was dismissed from service. And my lord, this investigation was going on. Now, my lord, during the course of the investigation,
Yes.
the investigation continued and ultimately on 30th of March 2021, my lord, kindly have a note of this, 30th March 2021 charge sheet was filed.
Yes.
Now, my lord, on the basis of the said charge sheet, when the file was mooted for my further extension during the month of March, my lord, my further vigilance department said since they are working regularly and her performance is good, it may be extended since only criminal case was incepted. But ultimate decision was taken whereby my service was not extended after 8th March 2022, my lord. 2022. Charge sheet was filed.
You was alleged as an accused.
I was alleged as an accused. Now, my lord, since it was not extended, I filed a case before the tribunal, the Central Administrative Tribunal, wherein I said that in this fashion I cannot be thrown out of service only because an FIR was initiated, a charge sheet was filed against me.
Yes.
Now, my lord, in tribunal held that tribunal accepted all my argument, and the tribunal said, since a criminal case is pending, we don't know what is the stage of the criminal case. Once the criminal case is over, you file an application before the authority saying that, and they will act according to that. I challenge it before the High Court. High Court also said the same thing, that you take recourse in respect of the criminal case. And my lord, in the meanwhile, what happened? Because we were working for more than 20 years, the department has a proposed recruitment rule Draft recruitment rule was prepared by the department, whereby the department saved the service of these two petitioners and four others who are working for 20 years. They sent it to the ministry for approval, saying that they are working from 20 years. Whatever recruitment rule will be framed, their right is to be protected, and they will be given regularization from the date of their initial appointment. Now, my lord, only because of this charge sheet, my service was not extended, and tomorrow if they come for regularization, I will not get
So
regularization.
you are here for discharge.
Discharge. And my lord, I will
Think against you.
yes, my lord. Now, my lord,
Criminal proceeding against you.
yes, my lord. Now, my lord, I will demonstrate from the charge sheet itself, my lord, what I have stated, that in Ayurvedic medicine, the technical head is Dr. Rajesh. I am a homeo doctor, and I will show the purchase committee, the promulgation of that.
What is the allegation level?
No allegation, no allegation. I am just showing. Kindly come to my lord. First, my lord, come to that document because of which I have been entangled in this case. Page number 22.
26 is the charge sheet.
26 is the charge sheet. 26 is the document because of which, irrespective of the fact whether I know or not, I have been entangled. Page 22.
Yes.
My lord, this is the Constitution of Purchase Committee dated 26 July 2002. It says in supersession of so-and-so, the Purchase Committee for procurement of, got it, my lord?
Yes.
Procurement of homeo and Ayurvedic medicine is constituted with the following members beside the undersigned as chairman. All the procurement of Ayurvedic homeo medicine will be finalized through central medical store on as and when required basis as per the so-and-so. My name appear at serial number 4 and serial number 3 is the petitioner in item number 2, my lord. Got it, my lord? It is homeo, my lord.
You are serial number
4, my lord. Dr. Savita, this one.
and who is on what did you say?
Serial number 3 is the petitioner in item number 2.
Dr. M.A. Jha.
My lord. Now, my lord, will find serial number 6 is K. Rajesh, my lord, Ayurvedic physician. Kindly have a note of this. Now, my lord, straight away come to the charge sheet, my lord. It starts from, the contention starts from page 48. My lord, may kindly come to page 49. I will only read the relevant portion, my lord. Kindly come to page 49. It says alleged offender. Got it, my lord? At the
Page 49.
page 49, my lord, third paragraph from bottom. There is a head note, alleged offender.
Yes.
Dr. K. Rajesh, the then medical officer, 2005-7. As per the direction of CVO contained in his letter dated so-and-so on the subject caption, procurement of Ayurvedic medicine for the use of Ayush Hospital, Port Blair at high rate under criminal conspiracy and fraud for cheating the government fund more than 50 lakh onwards. In the letter, it was directed to reconduct the inquiry of the matter in detail by clubbing with the report submitted by the committee constituted by the DHS to inquire into the subject matter. The report submitted by the anti-corruption while letter dated was concluded as not substantiated, was found incorrect. My lord, initial inquiry said not substantiated. Thereafter, it says on receipt of the above mentioned letter from the AS Vigilance, a detailed inquiry in the subject matter was conducted and relevant documents were collected from the DHS. From the collected document, it has been observed that during the financial year 2005-6, a tender quoted notice was floated by the then director DHS, while letter dated so-and-so for supply of as many as 1620 numbers of Ayurvedic medicine. For Ayush Hospital, as many as 14 firms submitted their quote, which was opened on so-and-so, valid till 31st March 2005. Now, my lord, kindly come to page 50. After the serial numbers are there, my lord, thereafter the following official of DHS were present who have appended their signature on the comparative statement. My name appeared at page number, serial number 4, my lord. Savita Biswas. She has signed in the comparative statement.
Yes.
Thereafter, my lord, from the comparative statement, it is found that the 3 firms, namely Amrita Healthcare Golgar, run by brother-in-law. Kindly have a note of this, my lord. Last paragraph, my lord. Up page 50, my lord.
Yes.
Brother-in-law of Dr. Rajesh, Sri T. Dinesh Kumar, Ashwin Agency, Premnagar, run by K. Rajesh, and Karuna Nursing Home, Premnagar, run by Dr. Bindu Rajesh, wife of Dr. K. Rajesh. MO Ayurvedic have quoted rate of almost all the Ayurvedic medicine published in the tender quotation, which means that all the medicines were available in the three firm. The order firm has not quoted rate of medicines which are not available with them. Thus, in absence of comparative rate, the three firm has taken the advantage and quoted high rate of almost all the medicine published by the tender quotation. It is also transpired that Dr. K. Rajesh, while serving as medical officer Ayush during the relevant period, has placed indent, kindly have a note of this, has placed indent of such medicine which are not available in Ayurvedic shops in Port Blair, most probably with the intention to extend beneficial help to his close relative running these three firms. In Port Blair, however, his connivance in influence the procurement process and helping the three firms to get the maximum tender cannot be ruled out. Now, my lord, after this, Amrita Care so and so got the highest rate. My lord, kindly, this all are with regard to those firms. Kindly come to the last paragraph of page 51. In order to ascertain and verify,
Yes.
verify the actual rate of Ayurvedic medicines at the local market at Port Blair, all Ayurvedic shops in Port Blair were contacted for analyzing the present market rate of such medicines, but they expressed their inability to provide the information as because the medicine are not available with them. Pausing for a minute, my lord will find that none of the local dealers able to give the rate of those medicines which were Ayurvedic. I, being an homeo doctor, I have got no access to those medicines, my lord. Now, my lord, kindly come to next page, my lord, para 2. From a point of view, it should have been the prime responsibility of the purchase committee to analyze either the local market rate or prefer with the price list of medicine and compare the same with the rate quoted by the firm before accepting the tender. Now, my lord, kindly come to page 53, conclusion. Conclusion, it says the inquiry conducted in the matter is concluded at the following point. First of all, Dr. Rajesh, medical officer himself, is a member of purchase committee in respect of procurement of Ayurvedic medicine. He is the officer who placed the intent of Ayurvedic medicine to the DHS for procurement. The three firm, namely so and so belongs to his relative, my lord. I have read earlier also. Thereafter, it says the three firm above have purposely quoted their rates of medicine much higher than the existing rate at the relevant time. They have cheated the government. The purchase committee comprising of so and so, my name is also there, failed to analyze the market rate of medicine before accepting the tender document. Thereafter, our name, the list is there. All the persons who are there in the purchase committee, their name were put, my lord. Now, my lord, kindly come to page 56. It says, second paragraph, on scrutiny of the comparative chart, it is established that the three firm, namely so and so, all the names are there, my lord. Also, Dr. Rajesh himself has issued an experience certificate on 3rd October 2001 to Mr. R. Rajesh Kumar while he was working in the nursing home. It is also a fact that on the basis of this certificate, R. Rajesh Kumar got license to run Ashwin agency and so. This nursing home was owned by Karnagaran, father-in-law of Dr. Rajesh, and later on the ownership was changed in favor of Dr. Bindu Rajesh, the wife of so and so. It is also a fact that all indent for Ayurvedic medicine used in the Ayush hospital were used to place by Dr. Rajesh only, and he was the only technical member. Got it, my lord? Second paragraph, last 3 lines. And he was the only technical member of the then purchase committee. So, my lord, he is the person who placed the tender. He is the technical person. The investigating officer themselves says he was the only technical person so far as Ayurvedic medicine is concerned, and he is the only person who has placed the intent. And on the basis of that only procurement was made. Now, my lord, kindly come to page 69. The rest are in between, my lord. Those pages are with regard to the rates given by the 14 firms. Now, my lord, kindly come to page 69. Third paragraph, my lord.
Yes.
From the investigation made so far, statement of witnesses, seized document and analysis of available price of medicine, it is well established that Dr. K. Rajesh, in connivance with the chairman and member of the purchase committee of DHS and other accused persons whose name are mentioned below, have procured Ayurvedic medicine for DHS during 2005, 2006 at an exorbitant rate of 15,84,000, causing a total loss of 11 lakh approximately to the government exchequer and so and so, so and so. So, my lord, the conclusion which has been arrived saying that the Dr. Rajesh in connivance with the chairman and the other members has procured. But my lord, the entire allegation made in the charge sheet clearly established that it was the Rajesh who was the technical head in Ayurvedic. It was Rajesh who placed the intent, and on the basis of the same where procurement were made. And even the police authority during the investigation, they tried to ascertain the rate from the local market, but they were unable since those medicines were not available in local market at Port Blair. So, my lord, only on the basis of this, there is no specific allegation against me. On the basis of this, my lord, this charge sheet was filed against me. And my lord, kindly appreciate, this was an incident of 2006, which was detected in the year 2012, and I was allowed to work up to 2022. I was not an FIR named accused. Only because my name appears in the purchase committee, I have been arraigned as an accused. So, my lord, no offense was constituted under section 2N of the Code of Criminal Procedure. This is an abuse of process of law, my lord. And I will show, my lords, the order whereby Rajesh was terminated from service in 2013 itself. Page 23. Entire allegation, my lord, was there. And they say that if my lord comes to last paragraph of page 23, whereas an inquiry committee constituted by DHS headed by the medical superintendent has submitted a detailed report in the matter, it was found that 3 major suppliers who participate in the tenders so and so during the period were owned by close relative of Dr. Rajesh, from which while so and so and whereas Rajesh belonged to, my lord, kindly come to page 24, second paragraph. Whereas Sri Rajesh being the lone technical member of purchase committee was responsible for scrutiny of technical and commercial bid, and he failed to intimate the department and the purchase committee of the fact that the supplier were closely related. Now, my lord, if assuming for argument's sake, if I was responsible, my lord, I could have been terminated from service in the year 2013 itself. Now, my lord, apart from this, what document I have placed before my lords, the charge sheet, there is no other allegation against me. And if my lord sees petitioner number 2, against him, there is no allegation at all. At least against this, only that comparative statement I have put sign. Petitioner number 2 has done nothing. Only last paragraph, Rajesh with the connivance and members of the purchase committee, he was arraigned as an accused. My lord, in this fashion, it cannot be. There must be a substantive evidence. FIR can be initiated against anybody, but charge sheet cannot be filed in a routine manner, my lord. And the CAT's order is there, my lord. If my lord, please, I can place those orders also.
These are not material.
Not material, my lord.
Yes.
No material.
My lord,
What are the evidences against the present petitions?
it is an admitted position, my lord, that
They were
Is a
the
member of the-
purchase committee.
member of the purchase committee. And being member of the purchase committee, not for the Ayurvedic medicines, but the homeo medicines, etc. This purchase committee alone, all the members, what is the purpose of it? What is the purpose of forming a committee to do to carry out a particular transaction in the department? Is a collective responsibility of all the members, that whatever the purchases are made, whether in Ayurvedic or in homeo, it is a departmental transaction, and the committee is formed to look after, to be watchful, and to see that the transactions are fairly made and no fraud is played. That is the purpose of the, otherwise there will be only one person to do the things. No, there is a committee. My lord, the liabilities and the responsibilities of the members of the purchase committee, it's everything there in a departmental file is rooted for that before the formation, and what is their duties, responsibilities, and liabilities is all a matter of record. All a matter of record, and those records are not before us. It's all, I mean, voluminous files or original files have been filed before the London trial court. So unless we go through those notings in the file as to what is the responsibilities of the committee formed and the members thereof, it would be difficult to appreciate the, unless we go through those records, how to make out then? Because in the charge sheet,
Okay, do you have
the
any?
copy of all
161
those records are
statements?
not the part of this charge
Do
sheet.
you have any 161 statements?
161 statement. (161) statement of one Dr. Avijit Roy. He was a member of the Departmental Inquiry Committee, because initial inquiry was conducted by the department. That is there in the case diary, my lord. And
Dr.
My
Abhijit
lord.
Rai.
Dr. Avijit Roy. Unless we go through or peruse those records, which are materials in the files, which are not part of the case
So
diaries.
your submission is there are some incriminating materials against the petitioners also.
Collective responsibility of the members of the committee as a whole. They cannot say that since it belonged to Ayurvedic medicines, I am not responsible for whatever is done there. Likewise, other cannot. It is a collective responsibility of all the members. They are equally liable.
Yes.
The fraud committed by this Dr. K. Rajesh, all the members are equally liable. And moreover, my lord, at this stage, we cannot just scrutinize or go into the
Yes. that I
materials
know.
in the
Yes.
investigations.
Okay, that I know.
The merits and demerits, we cannot
Yes,
go
yes.
into
Yes.
at
that-
this stage.
Yes, that.
The only thing that what has been laid down in the one Bhajandal case, it has been referred in Muhammad Javid and another was the share of UB and others by the Honorable Apex Court in the recent judgment, and that has been followed. Number one, the parameters are where the allegations made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. Second, where the allegations in the first information report and other materials, if any, accompanying in the FIR do not disclose the cognizable offense, justifying an investigation by police officer under 156 of 1 Code of Criminal Procedure. Third, where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out a case against the accused. And number 5, where the allegations made in the FIR or the complaint are absurd and inherently improbable on the basis of which no prudent person can ever reach to a conclusion that any offense has been committed.
That is C.H. Bhajanlal.
Bhajanlal.
Yes.
So that is the guidelines, my lord. In view of that, only we have to see the content of the FIR and the charge sheet and the involvement of the accused persons arranged in the case and have been charge sheeted as an accused. So if we see in totality, barring those materials which are there with regard to the duties, responsibilities, and the liabilities of the members of the purchase committee, that is only lying with in the files of the department, and that is with the honorable trial court have been submitted before the honorable trial court, and we cannot; those are not part of the case diary. Then it would be difficult to appreciate the
Okay.
In my submission is, my lord, that the matter may be state may be given some time. In the meantime, the lower court record and the records may be called for.
No, what
So
is
that-
what is the stage before the learned trial court?
Charge is not yet framed.
Charge is not yet.
Not get framed.
Charge sheet has been submitted, charge has not yet been framed. Very well.
What has been done by Dr. K. Rajesh, all the members are equally liable for the fraud he committed in
Yes.
matter of purchase of.
Hard. Please get down. The instant criminal revision has been preferred. Under section 482 of the Code of Criminal Procedure for causing the special case, causing a criminal proceeding being special case number 8 of 2021. 8 of 2021, pending against the present petitioner before the court of the special judge Andaman and Nicobar Islands at Port Blair by virtue of FIR number 1 of 2012 dated 30th March 2012 under section 13(1)(b) stroke 13(2) of Prevention of Corruption Act 1988, read with section 418, 420, 120(b), 34 of the Indian Penal Code, wherein the charge sheet being number 2 of 2021 dated 31st March of 2021 was filed against the present petitioner under the above mentioned sections. Above mentioned sections. The brief fact of the case is that the present petitioner was a member of the purchase committee constituted by virtue of an order dated 26th of July 2022.
2002, my lord.
Okay, 26th of July 2002 by the Directorate of Health Services, Andaman and Nicobar Islands, including a member, namely Dr. K. Rajesh, comma, Ayurveda physician. Stop. The committee was constituted for procurement of homeo and Ayurveda medicines. Initially, one FIR was lodged against Dr. K. Rajesh, contending inter alia that while he was working as a medical officer, on contract basis in the Ayush hospital under the Director of Health Services, and being a member of the purchase committee, it was found that three major suppliers who participated in the tender, namely Messrs. Corona Nursing Home, Messrs. Amrita Healthcare, and Messrs. Oshini Agency were owned by close relatives of Dr. K. Rajesh, and these three firms stroke suppliers together supplied medicines worth rupees 60 lakhs during the relevant period. Full stop. Moreover, ANCOFED and COFED, FED, from which medicines worth rupees 48 lakhs procured were in turn purchased from these Messrs. Corona Nursing Home. It has been found, it has been further alleged that, it has been further alleged that the medicines were procured at price as much as 15 times higher, as much as 15 times higher than the prevailing MRP. Stop. The FIR was registered in the year 2012 at Police Station Anti-Corruption against Sri Dr. Rajesh. Stop. The investigation of the police is ended in charge sheet. Ended in charge sheet. Stop. The charge sheet contains the name of Sri Rajesh along with the present petitioners and others. Stop. It is the case of the present petitioner that present petitioner was is a contractual doctor of doctor in homeophysician. And who is the Dr. M.A. Java program officer?
He is also a medical
Member,
officer,
But he
homeo.
was a program officer.
Yes, he was also the doctor, homeo doctor. Man.
Homeo. Okay. You will know? Doctor in homeopathy. Homeopathy. In homeopathy. And he was no way connected with the alleged offense. Stop. The Dr. K. Rajesh was sole responsible and technical member for placing the indent of Ayurvedic medicine. Thus, the alleged purchase of higher rate was made by virtue of the report of Dr. K. Rajesh, as he is the sole member of Ayurveda physician in the committee. This is the further case of the petition of that. There are no previous antecedent, regarding the involvement of the present petitioner in any of the allegation. Thus, at this juncture, the charge against the present petitioner are groundless. Charge against the present petitioner. Charges against the present petitioner are groundless, and the criminal proceeding against the present petitioner is liable to be coerced. Liable to be coerced. Pending against the present petitioner is liable to be dropped. Learned advocate for the present, next part, or the advocate for the petitioner submits that the allegation against the the charge sheet, the charge sheet filed by the investigating officer against the present petitioner is perfunctory. Stop. Perfunctory. The investigation would go to show that the present petitioner had no role to play to purchase the Ayurvedic medicine. Stop. Being only the member of the purchase committee, he cannot be arraigned as an accused in this criminal process. It is the further argument of the learned advocate for the petitioner that though the petitioner was a part and parcel of the purchase committee, which was constituted back in the year 2002, which was constituted long back in the year 2002. But the filing of the charge sheet against the present petitioner is without merit. They further argue that the present petitioner was a faithful contractual doctor since 20 years, and his contract was regularized time to time for a year by dint of the instant false criminal case. His service is at stake. At this juncture, the continuation of the criminal proceeding against the present petitioner shall cause irreparable loss to the petitioner. He prayed for necessary. Full stop. Next part, learned advocate appearing on behalf of the state submits that though the FIR was registered against the Dr. K. Rajesh, but after thorough investigation of the police, it appears that the present petitioner was also involved in the alleged offense. Full stop. There are sufficient materials with the investigating agency to frame charge against the present petition. We also argued that the IO has collected sufficient materials. IO has collected sufficient materials during the course of investigation. Stop. The available witnesses also disclose the involvement of the present petitioner in the alleged offense. Thus, at this juncture, the instant criminal case pending against the present petitioner cannot be coerced. We further argued that the present petitioner cannot avoid his collective responsibility as a member of the purchase committee. The petitioner has the active role to purchase the Ayurvedic medicine also. The Ayurvedic medicine also. Stop. He again argued that by virtue of the decision of Honorable Supreme Court passed in Muhammad Wajid and another versus state of UP and others, followed by the observation of Honorable Supreme Court passed in state of Haryana versus CH Bhajanlal. At this juncture, the criminal proceeding against the present petitioner cannot be coerced. Stop. Heard the learned
My
advocate?
lord, only one thing, my lord, only one thing. I am there in the committee only for the purpose of procurement of homeo medicine. It is not that I am a part of this. Because
Where is the separation, sir?
there is separation, my lord, because that's why Ayurvedic and homeo. Because that time the argument started when I said that there were 3 to 4 clinics. Therefore, one committee was constituted. In homeo medicine, I am the technical head to purchase. That's why I am in a committee, because my lord may take it otherwise that why I was in the committee. I was in the committee because Ayurvedic and homeo purchase committee was there, joint committee was there. I was there to purchase homeo medicine.
Such merit can be assessed like that.
No, my lord, this is the reason, my lord. Otherwise, there is no reason. If suppose it's a homeo medicine, then why Ayurvedic doctor did not have any say. And that's why, my lord, in the charge sheet, they have said that the technical, only technical person, if my lord sees the page 56, it was categorically
You have
said.
signed some quotation and everything.
No, I have not signed. Only comparative statement was signed.
Yes,
Yes.
you have signed the comparative statement.
My lord, I am a technical head so far as Ayurvedic is, homeo is concerned. Kindly appreciate this.
At this juncture, it cannot be going to the merit by this revisional
No,
court.
no, I am not on, my lord, I say, my lord, no prima facie case is made out.
No, privacy case is there. At this juncture, I cannot. You come with the discharge, then I can, at the filling of charge, you can, then I can go to the merit on to that extent.
My lord.
Whether there is a grounds to proceed. At this juncture, I have only to look into the merits as collected by the investigating agency. It was in the several judgments of the Supreme.
My lord, in that case, at least trial court may be directed to expeditiously.
Yes.
That can be done. I will not press this
I am also
application.
giving you leave. To
No, I am not pressing this. I am saying that 482, my lord, has power that the trial court may be directed to expeditiously take up the matter.
That was.
So I am not, my lord may not interfere with the merits, my lord.
No.
Yes.
I'm-
Only on with that regard, my lord, so that I can, once again, I can come
Yes.
if required. At this junction, this is my stand, my lord.
Oh, okay. Heard the learned advocate, peruse the materials and record, peruse the charge sheet. Charge sheet. It appears to me that the IO has collected some materials against the present petitioner. And considering the prima facie materials, the I had submitted the charge sheet against the present petition. The merits of the materials, cannot be assessed, assessed at this juncture. The value of evidences also cannot be determined by this revisional court at the stage of causing the proceeding after filing the charge sheet. It further appears to me that the charge is yet framed by the trial court, considering the entire circumstances and also considering the opinion of Honorable Supreme Court in Sage Bhajan, as well as other related judgments. I am of a specific view that the roaming inquiry regarding the merits of this case is not possible by the revisional court. Revisional court. Thus, I find no merit to entertain the instant criminal division. Stop. Considering the same, the criminal division is hereby dismissed. Stop. The learned trial court is directed to frame the charge as early as possible, most preferably.
Not frame the charge, my lord. Because at
Okay.
the stage of framing the charge, I have the right, my lord.
Proceed with the framing. No, frame the charge. Directed to proceed with this criminal, to proceed with the criminal proceeding as early as possible. The I made it clear that the revisional court, this revisional court has not gone into the merit of this case, and the petitioner is at liberty to challenge the charge sheet filed by the investigating agency at the appropriate stage.
Before the trial court.
Over the trial. Here is disposed of.
Grateful, my lord.
Want to say more?
My lord, 2 I will withdraw, my lord. Once there is an order, so 2 I will withdraw.
On the prayer of the learned advocate for the petitioner, the instant criminal division is dismissed as not placed.
And liberty to file as and when, my lord. Otherwise,
As not pressed, the petitioner is at liberty to challenge the charge sheet at the appropriate stage before the learned trial.
my lord,
Learned trial.
I am grateful.
Item number 3.
Item number 4, WPS 798 of 2023.
Lordship, I am for the petitioner. Lordship, on the last day of the last circuit, some bank statement and some documents were given to the petitioner so that he could be, the statement may be reconciled by the petitioner. And if found there's any discrepancy, he should come before the honorable court. But the problem is, Lordship, the petitioner has went to mainland for his father treatment. So I could not give him the statements. Lordship, what I pray, let this matter to be in the next debate on the first day, Lordship. Because this is very matter wherein the only source of employment, his car has been auctioned without due process of law.
Please take down. An accommodation is sought for on behalf of the petitioner. According the matter is adjourned today. Accordingly, the matter is adjourned today. List the matter on the first day of next available, sir.
I'm grateful, Lordship, highly grateful.
Yes, you have given me the.
Obliged, Lordship.
Item number 5. Lordship, I am very short point is involved. Someone has been notice has been served, Lordship.
My lord, Binu sir, got the instruction to appear for the respondent man. Binu sir.
The case is that, Lordship. The allegation.
This matter, I have just, my client has informed me over phone, he is a permanent resident of Billy Ground. He is coming day after tomorrow, my lord. I have just instructed that he will be engaging me, but unless and until I get the brief, unless and until, no, I was not there in the lower court. I was not there. I have just been assigned with the brief. I was not there. So, my lord, he is coming day after tomorrow, my lord. I have not been in.
Day after tomorrow.
Day after tomorrow.
Tomorrow.
My lord, he is from Billy Ground, my lord.
No, day after
My
tomorrow.
lord, he has not engaged. I am just informing because he has got the petition. So that's why I have just seen.
If he is not vigilant.
My lord, he is a senior citizen. He is in.
No, I can suggest, if he is a senior citizen, then advise him to take the take the records.
My lord, let it be day after, or in the next circuit, it was there, my lord.
If he want to present in the proceeding, then appear before the
Yes.
video conference. You can see the video conference.
I can satisfy.
My lord,
this
two
type
things
of
are there.
case.
Two things are there.
No, I can.
My lord, this is not the last matter, my lord. What I am seeking, I am not ready, my lord. On my ground, let it be urgent. Let it be urgent.
No issue.
I don't have the brief, my lord. I don't have the
That
brief.
is why I am.
Let it be in the next circuit, my lord.
Why
Let it be in
is
the
it
next.
next circuit? I don't understand. What is the reason?
I am not ready, my lord.
I am giving the copy to him. Very
It is
shortly.
not the way. It is not the way. My learned friend will accept the copy when I give to my learned friend without getting the instructions from the client.
Instructions. from
No,
the client.
there are material instruction is there.
Yes, that's why I don't want to use the word because it's a live streaming. That's why I have informed her in the morning itself.
Why the petitioner should suffer for material
I-
instruction
yes.
of the other council errors?
Okay, come on, day after tomorrow, I will take the matter.
Yes.
My lord.
Day after tomorrow. Okay. On the prayer of the respondent, the matter is urgent today. This the matter peremptorily. Day after tomorrow, that is respondent number 1.
Yes, it's one another.
Respondent the prayer of the learned, open for the respondent number 1. As a first matter.
Obliged.
Item number 6. Here are rating of 123.
My lord, in this matter, my lord, yesterday I have argued only section 7 and 8 has to be seen into, my lord, so far as my argument is concerned. my lord. 7 and 8 of the
According to
probation.
the case file which was provided by my learned brother, I find that there were 4 accused persons, out of which same allegation was there with the others also, and they have pleaded guilty.
Let me see 7 and 8. Yes,
Yes.
My lord,
So,
apart from just a minute, apart from this,
7 is there.
Yeah.
7 and 8 and section 2 subclause F may be seen, reserve area. Section 2 subclause F, read with section 3.
By notification.
No, my lord, kindly come to section 3. The chief commissioner may by notification declare any area, which is predominantly inhabited by aboriginal type to be a reserve area or any specific limit. Now, my lord, here admittedly in Campbell Bay, there is no aboriginal tribe.
No, it was declared as a reserve. Yeah?
No, my lord. Notification declare any area which is predominantly, kindly come to section 3, my lord, predominantly inhabited by aboriginal tribe to be reserved area. Kindly see section 3, my lord.
Yes, this is the.
The chief commissioner may by notification declare an area which is
Yes.
predominantly inhabited by aboriginal area.
No, no.
My lord,
It is
The
the
notification is to be
duty of the
challenged.
notification of the chief commissioner to notify the area which is predominantly.
correct. In
Okay.
Campbell Bay, there is no aboriginal tribe at all.
Whether it was notified area.
it was a notified
It
area.
is a notified area.
Yes.
It is a reserve area.
Yes.
So section 7 says in reserve area, without any member, only a member of Aboriginal tribe may roam. Okay, that is the only part.
And I am residing in this said area, that restricted area.
You may reside in that, but you are not the Aboriginal tribe, but you are the pass. You have the pass.
No, I am the permanent
know,
resident of
he's
that area.
Having any past.
I am the permanent resident of that area.
He is not a tribe.
So I am residing there. I have shown my
The
lord
entire area
map and
is
recording tree.
declared as an aboriginal tribe.
I am a permanent resident. There is a village.
Those all things have to be gone into.
No, why gone into this? Is
Everything.
when
is
that
decided
area, my lord, I have
in
shown the
this fashion.
document.
It cannot
How
be
it
decided
can
in this
be?
fashion.
How it can be?
The other twos have
The
accepted.
persons are residing there. It's a village.
Not only he went himself, he took two ex army officials. So that created a doubt.
So
Why they have taken the army officials, retired army officials. It's a sensitive area as well. Indira Point is a sensitive area. So it is not at all a case of discharge. We have to gone into everything. Now coming into before this honorable court that
Kindly see what is the allegation at page 35. What my London friend
there
says.
shouldn't be
That
any
is not
prima
the
facie
allegation.
case, but we can find a prima facie case here.
Page 37. Page 35. Second paragraph, my lord.
Yes.
It says दौरान तफ्तीश पाया गया कि 17 तारीख को 5:30 के आसपास निष्कम शर्मा सोएंसो कॉलोनी नियर सोएंसो मुंबई सोएंसो जो कोस्टल मेरीन कंस्ट्रक्शन एंड इंजीनियरिंग लिमिटेड के L&T कंपनी में प्रोजेक्ट मेरीना के जो जियोफिजिकल जियोटेक्निकल तथा टोपोग्राफिकल सर्वे में काम करता है, इस प्रोजेक्ट के काम के सिलसिले में और सर्वे एरिया की शुरुआती जानकारी प्राप्त करने प्रोजेक्ट साइट इंदिरा नगर के लिए रवाना हुआ। उनके साथ के सोएंसो राजेश ES राजेश के लिए रवाना हुए। उक्त चारों मुलजिम ने गलाती रिवर पहुंचकर BRO बॉर्डर रोड ऑर्गेनाइजेशन जनरल रिजर्व इंजीनियर फोर्स के डोंगी में गलाती रिवर को पार किया। नदी के द्वारा दूसरे तरफ गए। दो BRO वाले चोरों मुलजिमात एक ट्रक में 52 किलोमीटर में BRO कैंप तक गए। वहां से करीब 7:30 बजे 7:30 आवर्स को पैदल इंदिरा पॉइंट की ओर निकले। करीब 11:50 को इंदिरा पॉइंट पहुंचे और अपना प्रोजेक्ट के सर्वे एरिया लाइट हाउस और इंदिरा नगर जी के स्टैच्यू निरीक्षण किया। बाद में चारों मुलजिम शाम को 5:30 बजे के आसपास वापस कैम्बल में आए। दिस इज द एलिगेशन। Where is the Navy officer and all defense officer?
No, they are
This is the allegation.
no.
They have went in the vehicle of the government vehicle.
161.
That is the border
161. It is deputy.
border road organization general reserve engine force. The government in the government vessel they have travelled, my lord. It's the case of the prosecution.
Page 51 may be seen.
This is the charge sheet.
Then
Page 35 is the charge sheet.
तीनों लोग भी मौजूद थे। उप के दौरान जांच पड़ताल करते पर पता चला आर्मी के
I
रिटायर्ड
am a resident of that village.
आई कार्ड दिखाया तथा पूछने में बताया कि प्राइवेट कंपनी में काम करता है। जोलॉजिकल टेक्निकल एंड फिजिकल सर्वे के लिए आया हूँ। वह एक दिन पहले भी डिंगी से आने की कोशिश किया था। What does it mean? Everything cannot be gone into in this fashion by quashing the FIR and charge sheet. There is a prima facie case. The other two accused have admitted their guilt. If my learned brother is challenging the notification, he has to challenge the separate way, that there is no aboriginal tribe and this is not applicable in this particular area. As on today, upon our face, there is a notification which is standing. That doesn't give him a right to enter into it. He is aware of the fact, then also he has taken them. There is a permission required, which he ought to have taken.
Firemax has given him permission.
But Firemax is nobody. He has to obtain a.
No, there is a
from the
contract.
Commissioner.
There is a contract. The contract is there.
Contract would be there, but.
How the
to
person
enter
will
into
execute
that,
the
he has to
contract?
obtain a special
And my
permission.
lord, kindly see. My lord, even the punishment is 1,000 rupees. Why I am before this court? Only 1,000 rupees, the maximum punishment in section 8 subclause 2. I am a permanent resident there. I have all the authority.
No.
I have the contract is part of the contract, the agreement which was executed, that also I have enclosed. The Fairmax,
Entire Campbell Bay is a notified area.
I don't know, they
No,
say
no.
so.
No, certain area.
I am a permanent, born and brought up in kilometer
He
30.
claims that he is a
Gandhinagar.
resident of Gandhinagar, but where he had been, he has been to Indira Point. That is a restricted area.
Gandhinagar is also
required to
restricted
obtain-
area as per your notification.
He has to he is required to obtain a pass.
Whether he required to obtain a pass in the Gandhinagar.
Those things have to be looked
No,
into.
no, look into my learned friend may place the notification. Gandhinagar is a
Now, one thing,
notified area. I am
If that
I am
was
born and
so-
brought up in this.
if that
this
was
village.
so, that in the notification, it would have been reflected that resident of that particular persons are not governed. There's nothing in the notification as such.
We cannot assume.
That is why
Give me the notification.
that is why I.
Yes, let her place the notification. She is saying that there is a notification.
That is why I was-
The areas.
Lordship,
of the
that
lot.
is why I was saying, if this matter pertains to Campbell Bay area, the entire file has to come from
No,
Campbell Bay.
no,
area.
no, notification with the administration. Administration has issued the notification,
Then
not
let
the
it be
Campbell Bay.
fixed on, day after tomorrow, I will bring the notification.
My lord,
I'll
let
bring
it be
the
tomorrow, my lord. I will also try to bring, my lord. Let it be tomorrow.
Tomorrow.
They are the authority and they say that.
just
Let me try.
If you.
My letter
If
may be
possible,
having in
I'll-
our file.
I'll
Maybe
try.
she may
Okay,
be
I'm
having in
not
our file.
fixing it
having any
tomorrow.
file.
I'm
not
fixing
having
it
any file.
tomorrow.
Yes,
Okay,
I'll take a
if you-
chance.
You take a chance.
You know, I may be allowed to take leave.
Yes. Not today. Next.
Item number 7, Sierra 23 of 23.
My lord, I appear for the revisionist hearing, my lord.
I am looking for the other side. Here, I have received the entire amount. And as such, I am not interested in receiving it.
My lord, it was a case under section 138 of NI Act. I was convicted by the learned trial court. I preferred an appeal before the learned session judge. Session judge has upheld the order of conviction. Subsequently, the punishment was I was supposed to pay an amount of rupees 30 lakhs and not 37 lakhs with a simple imprisonment of 6 months. So that 37 lakhs I have already deposited. Now I have come up in a revision. I have come up, I can understand what your lordship has seen, I can understand. But we had moved this particular revision application, we have filed it. And at the time of filing, my lord, we were told that all the criminal matters would be taken up by this court number 2 only, my lord. We have in fact kindly see the top of that, my lord.
I understand, but it is the order passed by me also.
That is the thing, my lord. We have said so, but it was a.
I'm placing it before the learned court.
Can it be taken up today itself, my lord, if it is
Today,
placed?
You put the first magistrate first.
Tomorrow, my lord.
That is a matter of compounding.
It is compounding, 147, it will be compounded.
Only Small order. is
Small
taken.
order.
Okay,
I have, in fact, I have written in that particular presentation form also that it has to be placed before the court number 1. But they have said, no, the criminal matters would be placed before the court number 2 only, my lord.
done. Please take down. Please take down. The instant matter is released from the list on personal grounds. This is the matter. Tomorrow, we put the learned first bench.
My lord, I will have to mention before that court also not required, my lord, directly it will come, my lord. Once there is a direction, it will have to come before the court number 1, my lord.
Yes, you have mentioned it.
I will mention it.
Mention it. Before the learned first bench. Before the learned first bench. Parties are at liberty to miss. No, parties are at liberty to miss.
Item number 8, 039/23.
My lord, this matter, my senior will be appearing in this matter. Just not today, my lord. This matter can be taken up tomorrow
You are appearing?
for the petitioner.
It is
My senior will be addressing this matter.
not today.
Item number 9, WPA 975/23.
Lordship, I appear behalf of the petitioner.
Lord, I used to appear for the Portland Municipal Council in this matter, my lord, but I have not received the copy. Let my brother give a copy, my lord. Let it be not.
I have
today,
served the
tomorrow.
copy to the concerned department. I have also filed the affidavit of service. Affidavit of service. If the opposite party is need the copy,
You just hand over a copy.
Lord, I am appearing for 1 and 2.
3 के लिए.
3 के लिए तहसीलदार के लिए नहीं.
He is the Tahsildar.
Yes, my lord. I am appearing for the Portland Municipal Council and Secretary Portland Municipal Council.
Have you served upon the Tahsildar?
Your Lordship,
What is the prayer here?
the municipal council have ordered in the Manrit petition to demolish my building. Your Honor, the fact is,
No, where is the service upon the Tahsildar?
there, Your Lordship.
The municipal council.
I will be appearing for respond number 3. But I did not receive the copy.
To Tehsildar is in a downside, Your Lordship.
Okay.
Lord, it has been served on 16, my lord.
Yesterday.
48 hours had not been expired. So let it be
Lord,
not today, my lord. I did just.
What
the copy.
I pray, I serve the copy by hand, and this matter can be taken up tomorrow, Your Lordship.
Let it be, my lord.
Tomorrow?
My lord.
Sivabalam,
Yes, my lord. Let it be tomorrow.
what is the matter about?
So far as I remember, my lord, that is an order passed by this honorable court to carry out the demolition order passed by the PBMC. Subject to that, only the rider has been imposed and he should be given an opportunity of hearing. And then opportunity of hearing has been given, subsequently an order has been passed. Now, I think that order has been challenged in the instant request.
Your Lordship.
That's right. Okay, you serve. You have already served. Come on tomorrow.
Your Lordship.
Copies may be given.
I'll
You
day,
hand over a copy.
Your Lordship.
Yes.
Blair.
Complaint, my lord.
Item number 10, WPA 976/23.
Lord, I appeal for the petition in this matter.
This matter was given to me few minutes back, you know, because. The service was effected in the evening yesterday to the
No,
concerned
not sure.
bank.
The morning itself, it was affected actually.
I'm filing a wakalat now. I would pray.
Come on, next available circuit.
Lordship, that will not serve the purpose for which I have actually filed this writ application. The reason being that
You
at this,
served on only 16.
16.
Lordship, there was urgency, Lordship. The thing is that this particular matter basically I am a businessman running
Madam,
business.
are you ready?
No, I am not at all ready because it's a matter of bank and
So
DRT.
when you can ready?
Lordship, next circuit, I need some time to go
Lordship,
through and I have to
because
prepare
the
the
auction
affidavit as well.
Lordship, kindly appreciate, the auction date has been fixed on 6th of next month. Now we are going to start with the holidays from 20th.
I will challenge the maintenance.
I have already
Because
filed an
this is a
application.
DRT matter,
Lordship, I have already filed an application under section
default,
17,
chronic default.
subclause 1 of Surface Act before the DRT 2, Kolkata, which is pending. Now, recently, in the beginning of this month, they have published an auction notice to sell out the secured assets. So thereafter, I filed
It needs
two more
extensive
applications.
hearing, your
I
lordship.
may be allowed to make my submission, Lordship. 2 minutes, I'll take. Lordship, thereafter what happened? I have filed two more applications, one being put up application, another being interim injunction application before the DRT 2. However, DRT 2 is not functional since quite some time, as because there is no PO and no one has been given charge of DRT 2 as well. And I spoke to the court master this morning also. He said from 20th onwards, they have already received a resolution from the bar that they will start with the puja vacation, and before 15th it is not going to start. So I shall not be left remediless, Lordship. That's what I'm saying. I shall not be left remediless. Some protection may be given and thereafter the matter will proceed.
No.
Till
Can't
the
be.
time I am heard before the DRT.
Day after
Whether-
tomorrow?
Your lordship,
Day
whether it
after
is
tomorrow,
maintainable
if
or
you
not,
ready or on day after tomorrow?
lordship, in P, I
Lordship,
have to
I'm-
go through, I have to prepare a affidavit as well. I will raise preliminary objection.
I'm fixing day after tomorrow. If you are ready on day after tomorrow, then I could hear the matter. Otherwise, I will pass the one.
Lordship,
Lordship, as because the merits will not be decided by this honorable court, as because it is the subject matter of DRT. Only thing is that as because DRT is not functional.
Let me hear about.
Huh.
That's
so in
all.
that will,
That's all. Lordship.
the maintainability may be kept open.
Okay,
Absolutely.
everything would be happened. You come day after tomorrow, I will pass the one.
Lordship,
Deeply obliged. I'm grateful.
Day
I'm
after
grateful.
tomorrow. Number 11, WPN 978.
Lordship, I am for the petitioner.
I am for the respondent authority.
Lordship sees. I just came before this honorable court challenging the impugn order. Only two annexure is there.
It is also of HON'BLE, my lord, not served.
The predicament difficulty is that, your lordship.
Have you served?
Your lordship, I have served your lordship. This day I have through Heli, I have sent the same to the Tehsildar HON'BLE. But the problem is that, your lordship, kindly come to the order, impugn order, your lordship. In the impugn order, it has been stated that by 19th, the Tehsildar will demolish my house, your honor. So I need interim protection, your honor. And before that, I will come to this honorable court demonstrating that this order, impugn order, why it is impugned, your lordship.
Where is the impugn order?
It's last page, your lordship. Yes.
Okay, page 13.
Yes, your lordship. Prior to that, your lordship, one more annexure is there. My house may be seen. The entire order, your lordship. Yes. The Tehsildar, if I am not wrong, your lordship, the Tehsildar has passed this order for some extenuation consideration, lordship. Why I am saying so, your lordship sees from the starting of the order and to the end of the order, there is no whisper that I was given any opportunity of hearing or show cause or notice prior to taking such a serious step, your lordship. And if your lordship sees,
What is your name?
Purnima Mandal, your lordship.
Purnima Mandal.
Purnima Devnath, your lordship. In order number, serial number 8. The Tehsildar has very cleverly clapped the entire things, your lordship. There is some fishy thing, your lordship. From the order itself, your lordship may get, your lordship. And this puja is coming, your honor. I am living in a very mental depression condition, your lordship, due to this order passed by the Tehsildar, your lordship. Your lordship knows very well what is the procedure adopted by the administration. If any order has been passed prior to that, a show cause notice has to be issued, asking the concern to show.
Yes, you read the paragraph C of the order.
Yes, your lordship. Whereas another person, namely, whereas upon the report of surveyor, it revealed
No,
that.
above, third paragraph.
Yes, whereas this court issued a demarcation which was fixed on 27 February 2023, and notice were issued to all stakeholder departments, recorded tenant and other two persons who constructed temporary structure upon the land of, kindly, I'm just posing, land upon the survey number 6/2. 6/2, your lordship, prior to that, the complaint has been made by one Chittaranjan Mandal. He made a complaint before the Tehsildar concerned, stating that, your lordship, he intends to get demarcated his land, survey number 6/2. Kindly appreciate, then lordship, step by step, if your lordship gets the channel, your lordship can get the fishy thing what the Tehsildar intends to
Yes,
do.
read out.
No, your lordship. I'm just saying, whereas a complaint from Sri Chittaranjan Mandal, son of late H.L. Mandal, R.O. Ravindranagar village.
I have got it, paragraph 4.
I have 1, 2, 3, 4. Whereas upon the report of the surveyor, it reveals that an area of 0.1017 hectare out of survey number 6/2 is in physical possession of one Srimati Purnima Devnath, the petitioner hearing, and enjoying the area, enjoying the Arkanat plantation. Now, your honor. Also, she has constructed a new permanent structure which is let out as rent. Now, your lordship, the said newly constructed permanent structure is partly constructed over survey number 8, which is recognized as government path. Next, your lordship. Whereas another person, namely Srimati Kalamati Malik, has constructed a semi-permanent structure occupying an area of such and such out of survey number 6/12. 6/12, and also enjoying Arkanat plantation over the recorded land of Chittaranjan Mandal. 6/12 came, your lordship. Whereas in the top, at the best, your lordship, if the demarcation was applied by any incumbent, your lordship, and the demarcation is done. Demarcation is
No,
done.
demarcation in respect of 6/2 is sought for.
Sought for, your lordship.
And it was
Now
appeared in
the-
the report that the 6/2 was in physical position of the.
Some part of my, yes,
By the
yes.
Some arcana not.
Yes, your lordship.
6/12 is another.
Another land, lordship.
Another land.
Yes, your lordship. This is.
So what is your submission?
My submission is that, your lordship, I have, as per the settled principle of law, your lordship, at the face of the order itself, your lordship can see in the last, he has directly stated that under 104, I am going to get demolish the land. No show cause, no opportunities. It's a clear violation of national justice, your lordship.
You have served.
No.
Served the notice.
No.
Before the.
No, your lordship. No, not at all. With regard to this aspect of the matter, 104.
Take the instruction whether any notice was served upon the petitioner before the survey or anything, not the hearing.
My lord.
Yes, your lordship. No, nothing has been served, your lordship.
From listening, I can understand, my lord, there is a private respondent is also there. I
Yeah.
don't know whether they have made the private.
I am not interested in
Party.
private respondent, lordship.
Because
Respondent in respect of
If he is
plot
ag-
number
Yes.
6/12.
there is a complaint
Look,
against,
there is a complaint in respect of 6/2 by one Chittaranjan.
yes,
So I pray,
They have
only
not been arraigned as a party in this
there
case.
will be no
they are
heaven will,
interested parties.
heaven will fall, your lordship. The allegation is that I have encroached government footpath. If you kindly see the photograph, your lordship, kindly see the photograph. Where is the block road and where is my house? So interim protection may be given, your lordship. It will be balance of convenience with the petitioner, your lordship. The puja season is going on. I am in deep mental depression, your lordship, that my house will be demolished. So some interim protection may be given, let my learned friend get the opposition, your lordship. Till that time, your lordship, may I celebrate the puja and kindly appreciate it. With family, your lordship,
What
will
is your
be
submission?
interim
My lord,
protection.
I
may be
have
given.
not seen the, because it is a matter pertaining to HON'BLE Tahsildar. and copy has not been served. So I'm until I see the color of the paper, I cannot submit.
19th, then day after tomorrow, your lordship, it will be. It's a straight away commanding order, your lordship. Your lordship knows very well, your lordship. Some interim protection, that your lordship kindly appreciate, there is no allegation. It's a matter of house shelter, your lordship. The interest of justice, your lordship. I am having children, family, your lordship.
Please take down. The instant writ petition was preferred against the order dated 10th of October 2023 passed by the Tehsildar written in the morning. In RC number 189, stroke TLA stroke 2023. Stop. Learned advocate appearing on behalf of the petitioner submits that order of demolition of the sole residential house was passed by the concerned Tehsildar in exercise of power under section 104 4 of the Andaman Nicobar Islands, LR and LRR 1968, without giving an opportunity of the present petitioner of being heard. Stop. Learned advocate appearing on behalf of the respondent administration submits that the order was passed by virtue of an application by a complaint of application complaint virtue of a complaint of one private respondent who was not made a party in this process.
My lord.
It is a submission.
My submission.
Party in this proceeding. Stop. He further submits that. He further submits that he requires instruction to enlighten this court whether the required notice was served upon the petitioner or not. Petitioner or not. Before passing the impugned order. Considering the same, the matter is considering the same, the petitioner is directed to serve upon the respondent authority regarding the copy of the application along with the copy of the petition, copy of the petition along with the copy of the impugned order. Let the matter appear in the next appellate circuit. Stop. In the meantime, the respondent authority is directed not to demolish the present petitioner from the land in question. Stop. The petitioner is also directed to not raise any type of construction, whether permanent or temporary, over the land in question.
Deeply obliged.
Obliged, my lord.
Item number 12. WTA 9
But I am praying for not today in absence of Mr. Chakraborty, because this matter we have only received
No, the problem
yesterday
would be-
evening, my lord.
No, the problem would be, I don't stand in the way. The problem would be, as I've said at the first instance, when Malott took the chair, some urgency is there. tomorrow is the only day which my lord knows working would be. I am praying for certain interim protection.
What is this?
My lord.
What is the issue?
My lord, the writ petitioner.
A time can be fixed
No,
tomorrow.
just 1 second, just 1 second. Now, the writ petitioner
Let me hear out.
completed her graduation of law from a recognized university. She started practicing here. Lord, while practicing, she was offered with a job as law officer under the Andaman Nicobar administration, which she is doing presently. Lord, the respondents floated a vacancy notice. I'll just show that. Now, it's at page, I'll just show, page 48. Vacancy notice in respect of the post of labor inspector. Lord, online applications were called for. My client applied with all documents. Lord, she was shortlisted in the merit, on merit. I'll just show that merit list at page 61. Lord, kindly see, before that, a hall ticket needs to be seen because the roll number, ticket number, so only I can compare this with the merit marks. Lord, kindly see the hall ticket of my client.
60.
No, before that, not page 60, yes. Not would find the name of the writ petition, it's in hall ticket pursuant to the notice being floated. Not would find at serial number 3, roll number and ticket number is 1362 and 5005. Well, got it? Page 60, the name of the candidate is Santoshi Devi, page 60. Hall ticket for the said post, a roll number and ticket number 1362 and 5005.
Yes.
No, written exams were held, and page 61, my lord, the results on merit were published. My lord, kindly see, altogether 23 candidates were given with the hall ticket. Some of them are absent. My lord could find at the last column my client's name. It's not name, it's her ticket number and roll number. My lord would find at serial number 5. Same 1362, roll number 5005.
Yes.
Now she secured first 63.75.
Yes.
It's the top one. Now would see the marks scored by other aspirants. The 5 serial number is my writ petition 6375. The other is at 10, 6350. Posts are 2 in numbers.
Yes.
Now, page 62, a notice was again published by the respondents inviting claims and objection with reference to the question papers and answer sheet, because once the written exams are being done, this practice are being followed. Notice was published, and my lord would find in this notice at page 62, a cutoff date was prescribed. It is one who have any claims on objection within this time, 1 September 2020, third line note from the top, 2/3/9/2023, they can raise an objection. No, nothing was placed before the authority during this period. No, these are the right from page 63 question papers with the answer keys. One could find question paper starts at page 63. Answer keys is at page 91. 91.
Yes.
Note, page 94 is the relevant page. On 24th August 2023, I'll just place this notice. The following aspirant candidates who appear for the written examination on 19/8/2023 at Andaman Law College, Port Blair, for the post of Labour Inspector Group B non-gazetted in the Department of Labour, Andaman Nicobar, are hereby instructed to produce all certificates, testimonials, documents in original, along with self-attested copies for verification on 15/9/2023 at 10 a.m. in the Office of Labour Commissioner and Director of Employment and Training Supply Line for preparation of a list of top 3 merit. Now the keywords are, out of this 10, 3 top merit aspirant would be selected. My client's name is at serial number 4. Written statement results is, I'll show at serial number 5, she has secured more marks. First, she's in the first position. No, nothing was done. On this date, on the scheduled date, no verification was done. She was given assurance that you would be put in notice as regards the verification on some other date. Nothing was done. I made a representation at page 95. P9, requesting the authority to implement the very process. 95. So this was the cause of everything at page, issuing on page 98. It's a notice in the Daily Telegram of 14th October 23 issue. But kindly see it at the top. Newspaper date is 14th October. Now kindly see the tabulation in the middle. Notice. Now it's very short. I'll place it. I have marked. Can find it.
Yes.
it is hereby informed to the concerned that the written examination conducted on 19/8/2023, that's the labor inspector, at Andaman Law College to filling of 2 numbers of regular and 1 anticipated post of labor inspector group B non-gazetted, pay level so and so, stands cancelled due to administrative reason. That's one first point. Re-examination in the computer-based test mode will be conducted on 10/11/2023, Friday at Dibret, Dollyganj. All eligible candidates are requested to visit this link for their admit card. My lord, the judgment of the apex court is very clear. If there is any reasoning, they have to spell it out. On this, just they said it's an administrative reason, it has been cancelled. They cannot do it. This first point. Secondly, by inviting even others who were found absent, my lord, I've shown that. They are giving invitation even to those who did not attend the exam on 19/8/2023. But this is nothing but because I secured more mark, some of my well-wishers have thought not I should not be get appointment. That's the reason. No claims and objection were filed. Even if it is filed, I've taken a specific stand. It are belated applications. I'm praying, Lordship, because not most puja vacation is ensuing. Lord, CAT, I cannot approach now. I have the judgment of the apex court. I brought it. It's in the case of T.K. Rangarajan. I'm placing the judgment, Lord. Even service matters, they may take this point in their in replying to my interim protection prayer. In this judgment, L. Chandra Kumar judgment, because the L. Chandra Kumar judgment is a judgment which is governing the field, which says that all service matter has to be approached to the tribunal. First of all, I would say it's not a service matter because I have not yet been appointed, my lord.
Yes.
Secondly, even if for the sake of argument, I say that it's a service matter, then also this T.K. Rangarajan judgment, I'll just showcase that paragraph, my lord. L. Chandra Kumar was taken into account, paragraph 5 and 10. I will place, my lord. Under Article 226 of Constitution of High Court is empowered to exercise extraordinary jurisdiction to meet unprecedented extraordinary situation having no parallel. It is equally true that extraordinary powers are required to be sparingly used. The present case is not most extraordinary, which calls for interference by High Court, as the state government has dismissed about 2 lakhs employees for going on strike. Also in Tamil Nadu, at the time, the administrative tribunal was made by only 1 person. Though the judgment of the larger bench in L. Chandra Kumar case 1997-3 SEC 261 is binding on the present bench, however, that if the thousands of employees were directed to approach the administrative tribunal, the tribunal would not be in a position to render justice to the cause. Hence, it is held that because of very, very exceptional circumstances that arose in this case, there was no justifiable reason for the High Court not to entertain the petition on the ground of alternative remedy provided under the statute. So they may take, I'm sure they would take this point that this court is not vested with the jurisdiction because they say that it to be a service matter. I say it's not a service matter. No, service matter in terms of the administrative tribunal rules. What I have, my understanding is, if I could have been given offer of appointment, I have expressed my willingness. Appointment order is given. The aspirant who are unsuccessful, they can approach. Till now, they have issued this publication saying that the written examination held on 19/8/2023 for administrative reason. What is the administrative reason? I just fail to understand. But what I have did, I applied under the right to information. You show me what is the administrative reason. In a very lethargic manner, it has been rejected. Page 99, may kindly be seen, Lordship, and letter P11. I have invoked the Right to Information Act. I have sought for the information. Just furnish me the reasoning. And they give the reply at page 101. Same, Lordship, stereotype, section 8 RTI comes into play, will not furnish it. Not in a public post, transparency needs to be maintained. Our court, not in an identical, though facts were different, allowed the writ petition. A lawyer approached this court under Article 226, service rating matter. So mainly, my argument would be two-folded. First of all, I'm saying that it's not a service matter. So this court is vested with the jurisdiction. If this court for any reason says no, it has a color of service matter. Even then, the judgment of apex court of Rangarajan as well as of the single judge comes to my aid. I am praying for interim because Lordship, after 2 days, vacation would start. The next circuit of High Court is 16th November. CAT sits at Calcutta in the 3rd week of November. And 10th of November 2023 was the deadline prescribed. See, kindly appreciate the game of the authority. They have found that I am secured more mark. Some of my well-wishers have said, Lordship. They, Lordship, reason best known to the authority have acted at their behest. The impugned publication has been made. But this needs to be stayed. The impugned notice needs to be stayed, Lordship. Otherwise, Lordship, I would be the ultimate sufferer. This is my limited prayer, Lordship, with regard to the interim protection. I'm sure this point they would raise. This court is not amenable to the matter. It's as a service. I say no. Even if this court overrules and sustain their point, my TK Rangajan case is very clear.
First of all, we have preliminary objection with this L. Chandra Kumar is correctly said. I will raise objection with L. Chandra Kumar judgment. There is one more judgment, my lord. First of all, the praying time. Secondly, my lord, there was these people where interim order should be passed, where people are starving, where heavens will fall. There, in that cases, interim order should be passed. But I am paying only 1 day time, my lord. First of all, these people who have given exam, they are already doing us administrative service. They all are law officer of the administration. Part-time. That is not the issue. Now, the reason for re-examination is that out of 100 questions, the objection were raised within 3 days. They have been given time. After the examination has been called, they have given time that you raise objection within 3 days. 3 days, some of the candidates have raised objection. They have stated 28 questions were wrong. Number thereafter, administration has checked up and asked them, you provide us the question. They have provided the questions. Administration has scrutinized them and found that 24 questions were wrong. Number out of 100 questions, if 3 questions, 4 questions were wrong, that can be admitted. But 24 questions were wrong. That's why, my lord, they have seek instruction from the labor commissioner and till the CAs. All have
come with the affidavit.
My lord.
Till such time.
No, my lord. No,
kindly appreciate.
my lord, they will not be accepted. With giving examination, he can definitely exam as well.
What my
24 questions.
what my draft is saying must find
24 other persons' rights will also be
this way this can't be.
Other persons' rights will also get affected, my lord.
When you come with the affidavit tomorrow,
But tomorrow, my affidavit is not possible. We can file our short reply, my lord. The law.
you file short reply.
Short
But
reply.
till such time, Lordship's protection.
Tomorrow.
Tomorrow.
10th November is time.
You file any reply, anything.
He wants 10 days time, Lord. He
No,
wants.
I am saying that there is a time in 10th November. That I am saying, my lord.
Okay, not today.
Lord, some preference, otherwise, my Lordship, it would remain.
No, 10th November, there is that exam. Tomorrow, I file my report.
Submission.
Tomorrow.
You come to this island and you are appearing for the administration and you fight for against the lawyer of this court. This is very bad. I'm on merit. I'm not on sympathy ground. I'm on merit.
Please take down.
My, I am paying no interim order might be passed.
I am not passing today until I am fixing the date tomorrow.
Tomorrow, my lord.
Okay. On the prayer of the learned advocate appearing on behalf of the administration, the matter is adjourned today. This is the matter tomorrow within first 5 minutes.
I'm grateful. I'm grateful.
Grateful.
I'm grateful.
Next. Item number 13.
I pay for the state, your lordship.
State appeal.
State appeal
Which for
against
the
acquittal. The other side has not yet entered appearance. So this has to go to next.
next circuit. Next circuit. Okay. Read the matter. Go out of the next. The matter. It's for next available circuit. Yes. Item number 14.
But this matter is before Supreme Court. There is a Supreme notice has been issued in this matter, my lord.
This may inquire and come back here.
Yes.
One copy is here.
80 copies. So number.
Next circuit.
Let me look into it because the order is on August 2022. Possibly with the difference we don't know. Because last occasion also, this type of submission was made, but we found subsequently that its case has been dismissed. So it will be listed tomorrow, let me look into it.
No, what is this matters?
The contempt matter, my lord, this is.
Contempt
Contempt
matter,
matter.
whether this single bench can hurt the contempt matter,
Yes.
A single bench can hurt the contempt matter if the.
but why it was released by the court on 2nd of August 2023?
Because they said, your lordship, that they will be filing the SLP.
SLP and SLP is filed,
No,
notice
it
has
is
been.
lack of determination is the order. Lack of determination is the order.
That should not have been there.
Yes. Lack of determination is the order. That's why I'm asking you.
Because even I am not aware, but it has been just shifted. Because they have submitted that they will be filing SLP.
Why it can happen that at the time of circuit that has been filed before principal then so. I don't know why this is.
Okay, fixing tomorrow, just.
Tomorrow, I'll just inquire if SLP is still pending or not.
Next,
Item number 15.
My 15 to 18, my lord, appeals are pending. Your lordship sitting in division bench has passed an order. So, my lord, in single, my lord, just because been made next circuit, so, my lord.
yes. Order passed by the division bench.
My lord. It's appeals are pending, my lord.
Oh, appeals are pending.
Yes. So 15 to 18, lordship, let it be the next step.
Next.
Yes. 15 to 18 next circuit.
Yes.
ये तो जाएगा वहाँ मन जाएगा
The appeals are pending. So the matter may appear in the next appellate circuit. List the matter in the next appellate circuit. List the matter in the next appellate circuit. Next.
Item number 19. Your lordship, this order was passed by Honorable Justice Rajshekhar Manda. So it has to go to the video conference. Registry may be directed to place the matter to video conference.
The alleged order was next. Please take down, Item 19. The alleged order was passed. Impugn order was passed by the Honorable Justice Rajshekhar Mantha. No. By a coordinate bench of this court. A coordinate bench of this court. So the matter we go out of the list. Stop. The registrar. Circuit bench 4 where is directed to arrange for hearing through video conference. Next. Item number 20, here are 28 of 2019. Not today. Okay. Item 21, WPA 113 of 2019 with item number 22, 3, 23, 24, 25.
I am appealing for the petition. But I am for the respondent, my lord, Dr. Devesh Chakravarti is there, my lord, in this matter.
So what can we do tomorrow?
Tomorrow,
Mr. Chakravarti is.
tomorrow, day after, he will come, my lord, because
Day after tomorrow is not possible to hear in the past.
tomorrow let it be fixed, my lord. We are also at difficulty because Mr. Chakrabarti cannot be at two places.
Very well. Not today.
Item number 26, WPA 263 of 2019.
Next circuit. Next. Next. No urgency.
Next, sir.
Item number 27, WPA 267 of 2019.
I am appearing for the petition.
Not today, my lord, in this
That is in
matter.
the next circuit.
Next circuit.
Next circuit.
Item number 28, WPA 289 of 2019.
Very else.
We are for the respondent, but Deep sir is there, so.
Next circuit.
circuit, my lord.
No, copy of application. Very good.
Gate.
Next matter tomorrow.